My district is one of many in our state that has experienced severe drought in recent years. And in this time, my knowledge and understanding of water issues has expanded rapidly, as I've heard from farmers, ranchers, wineries, irrigation districts, drinking water providers, fish advocates, and our local water master's office about an array of water issues. The common thread among them is the enormous concern about the shortage of water, often a result of climate-related impacts on our snowpack, our groundwater, streams and rivers, and in our reservoirs. But compounding these dire circumstances, and certainly to our dismay, are egregious water violations, the intentional misuse of water, including use or storage of water without a water right, continued water use or interference with a locked head gate that was turned off by a water master, use of another person's water right without authorization. These violations consume our most precious natural resource with impacts on livelihoods, on wildlife, water quality, recreation, tourism, and more. Yet, when our water masters see these violations, in order to stop them, they must navigate an administrative enforcement process that can drag on for months. With climate change upon us and increasing incidents of drought, the state needs to act to protect lawful users and public resources in times of water scarcity. House Bill 2929 will give the Oregon Water Resources Department the authority to seek injunctive relief when the department has evidence that a person has engaged in water use violations. The court injunction can require the user to immediately stop illegal water use and to remedy any effects of the violation. Injunctive relief will provide the department with a tool to quickly address unlawful water use and to minimize impacts to lawful users and public water supplies. House Bill 2929 simply gives the department the ability to petition for relief in a circuit court. The court will then decide whether the harm asserted outweighs any harm to the opposing party. The court will review the situation and hear from both the state and the individual or entity that is the subject of the enforcement action. That hearing provides essential due process protection. The court will move forward with a temporary injunction only if provided adequate evidence of harm. The department could seek injunctive relief only in cases of clear illegal water use that is causing or that will result in irreparable injury, such as illegally withdrawing water from a stream or illegally digging and filling a pond. The amendment that was attached to the bill requires OWRD to report to the legislature on the use of the injunctive authority tool in 2029. Without legislative action, the program will sunset in 2030. By then, we will know if injunctive authority has been useful and effective, and the legislature at that time can decide whether to extend its application. Mr. Speaker, like many Oregonians across the state, constituents in my district cannot wait for bureaucracy to run its course while crops wither, livestock suffers, and fish die. I ask you to give the state this simple and narrow remedy to swiftly protect our water resources with an aye vote on House Bill 2929.
Representative Marsh, do you wish to close?
Thank you, Mr. Speaker. Just a few comments. First, I do want to correct the record that the agency is neutral on this bill. The bill was all my idea. They do not have a position on it. I want to respond to just a few of the comments that were made. I think it is clear that administrative action will always be the first approach that's utilized by OWRD and water masters. But this process requires documentation and due process, and as a result, it simply takes a while. Now, I would argue that that's appropriate, because our goal should be always to seek compliance with the law, not to punish people. Civil penalties can be issued only after a water user fails to comply with a notice of violation, and at that time, a notice of assessment is issued to begin the process of assessing civil penalties. So all of that process can take months. We know that senior water users cannot afford to wait while their upstream neighbors illegally divert water from an irrigation ditch, and we know that fish may not survive when water is illegally pumped from creeks. These are times when immediate action is necessary to address egregious illegal use of water. As in the issuance of any injunction, The court will listen to all parties. There is due process, and the court will decide if the evidence of irreparable harm is sufficient to support a temporary, preliminary, or permanent injunction. Injunctive authority will give a water master the opportunity to intervene immediately to save water and potentially remediate damage. If there is illegal pumping from a stream, the order may include dismantling and removing the illegal irrigation system. If the violation is a dam in an irrigation ditch, the court may order the dam to be breached. Mr. Speaker, administrative actions will continue to be the predominant approach with injunctive authority reserved for emergencies. The legislature has already agreed that injunctive authority can be used to protect against dam failures and poorly constructed wells. At a time when water is limited and demands are high, we need to ensure that the agency has the tools that it needs to protect water users and wildlife from the damaging impacts of water theft. I urge an aye vote.